Imagine for a moment the unthinkable happens. Someone you care deeply about passes away. In that initial wave of grief and emotion, practical questions almost immediately start to surface. What happens to their home, their savings, those treasured family heirlooms? Who decides where everything goes? It's a moment of profound personal loss, yes, but also one that very quickly introduces complex, practical, and, well, legal decisions, often at the worst possible time. Today, we're taking a deep dive into what is arguably the most fundamental distinction in probate law. It's the critical fork in the road, really, that determines the entire path an estate will take after someone has passed. We're going to unravel the intricacies of what happens if someone dies testate, meaning they left behind a valid will, versus intestate, when there is no legally recognized will. We've pulled together a fantastic stack of insights to unpack, and our mission in this deep dive is to give you a clear, comprehensive roadmap through these two incredibly different scenarios, hopefully equipping you with insights you might not find just, searching online quickly.
Absolutely. And understanding this distinction, it goes far beyond just getting a handle on legal jargon, doesn't it?
Yeah.
It directly impacts real families, real legacies, and the ultimate distribution of a person's life's work, their accumulated possessions, their values. It fundamentally determines whether your explicit wishes, or the carefully considered wishes of someone you care about, are actually carried out, or if the state is forced to step in and make those incredibly personal decisions for you.
Okay, let's unpack this right from the beginning one, because this really is the bedrock of everything else we'll discuss. What's the core defining difference between someone dying testate and someone dying intestate? What is that fundamental fork in the road we need to understand?
Right. At its heart, the distinction is elegantly simple, yet utterly foundational to how an estate is probated. When we say someone dies testate, it means they passed away with a valid will in place. This document, hopefully meticulously prepared, it articulates their wishes for how their assets should be distributed, who should receive them, and often who should manage the process.
Okay, so testate equals valid will.
Exactly. Conversely, dying intestate means someone has passed away without a legally recognized will. This might be because they never created one, or maybe the one they did create was somehow deemed invalid by the court later on. This distinction sets the entire course for what comes next in the probate court. It's the first question asked, really.
So it really boils down to whether you've left instructions, clear instructions. Now let's trace that first path, the one where careful planning has laid out a clear roadmap. What does it look like when someone has truly prepared, leaving behind a valid will? What's the process here? And crucially, who is in charge of bringing those wishes to life?
Okay, so in a testate succession, the decedent's will is truly the commanding voice. It's almost like their final operating manual. It dictates precisely how the estate is to be distributed. Their wishes, carefully laid out, are paramount. The first crucial role here is the executor.
The executor.
This is the specific person, or sometimes an entity like a bank, named by the decedent in their will to carry out these instructions. Their initial step is typically to file that will with the appropriate court, often called the probate court.
And the probate court, in this scenario, its role isn't making new decisions, is it? It's more about ensuring the existing ones are followed.
Exactly. That's spot on. The probate court's role then becomes one of verification and oversight. It's not about redeciding who gets what. It's about ensuring the decedent's intent is fulfilled according to the law. The court verifies the will's authenticity, confirming it's indeed the last valid expression of the decedent's wishes, that it was properly signed, witnessed, all those formalities.
Making sure it's legitimate.
Right. Once verified, it formally appoints the executor named in the will. So the court's primary job is to oversee that those expressed wishes, as detailed in the will, are indeed carried out correctly, legally, and hopefully without undue delay.
It sounds like an executor is almost like a temporary CEO of the deceased's entire legacy. What's the most surprising or maybe emotionally challenging aspect of that role that people rarely consider? I can imagine it's not just shuffling papers.
That's a great analogy, a temporary CEO. And yes, it's far more than just paperwork. The executor's responsibilities are quite extensive and carry significant legal and emotional weight. They are tasked with collecting all of the decedent's assets. Everything. Pretty much. Ensuring all legitimate debts and taxes are paid from the estate, and finally transferring the property that was bequeathed, given to the named beneficiaries. What's often surprising is just the sheer breadth of assets and liabilities they might encounter. Bank accounts, real estate, sure, but also forgotten subscriptions, digital assets, complex business interests.
Yeah.
And emotionally, they're often dealing with grieving family members, some of whom might disagree with the will's provisions. That creates an incredibly delicate balancing act.
I can only imagine.
But there are definite advantages to having a will, even with those challenges. In many states, a clear, well-drafted will can significantly help streamline the probate process.
How so?
Well, for instance, wills can grant the executor broader powers to manage the estate without needing constant court approvals for every little transaction. That saves time and money. They can also sometimes waive certain requirements, like the need to provide formal notice to minor beneficiaries in some cases, or even streamline the sale of property, all of which can dramatically speed things up and lower the overall legal fees. It really does offer a smoother path generally, even when facing a difficult transition.
That does sound like a clear advantage, especially in terms of efficiency and cost. But playing devil's advocate for a moment, even with a perfectly crafted will, does that mean probate is always completely avoided? Or are there still instances where the court needs to get involved for certain assets?
That's a crucial nuance and a common misconception. Very important point. Even with a perfectly valid will, probate is usually still required. Yes, unless all the assets have non-probate transfer mechanisms already in place. These are tools designed to transfer ownership automatically upon death. They essentially operate outside the will and the probate court's direct supervision.
Like what kind of things?
Think of assets held in a living trust, or life insurance policies with designated beneficiaries already named, or bank accounts and real estate held in joint ownership with a right of survivorship.
Okay, so those bypass probate automatically.
Exactly, because their transfer is dictated by their own legal structure, not the will. But for everything else, assets solely in the decedent's name without such mechanisms, the will provides the instruction manual that the probate court then oversees to ensure proper distribution.
Right. So a will clarifies your wishes, streamlines the process, potentially saves time and money, but isn't a magic bullet for all assets if they aren't structured specifically to avoid probate. Okay, let's flip the coin, though. What if there's no valid will? This is often where things can become quite surprising and potentially very complex for families who are already navigating a really difficult time.
This is where the landscape shifts dramatically. If someone dies without a valid will intestate, it's the state's intestacy laws that step in to determine who inherits the property. Full stop.
The state decides.
The state decides. The decedent's personal wishes, no matter what they might have expressed informally during their lifetime, maybe told friends or family, those are no longer a legal factor here. The law dictates, purely and simply, based on a predefined hierarchy of familial relationships.
Okay, so how does that process start? Is it still through the court?
Yes. The probate process for intestacy still begins with a court petition, but this time it's specifically a petition for the administration of an intestate estate, and the court will still appoint an individual to manage things, known as an administrator.
An administrator, not an executor.
Correct. They function similarly to an executor in managing the estate. However, unlike an executor, the administrator is appointed by the court, usually based on a statutory priority list, not named by the decedent in a will. And their primary role is to strictly follow the statutory rules of the state in question. They have much less discretion than an executor who is guided by the specific instructions in a will.
So without a will, the state effectively writes your will for you after the fact. And it has a very specific pecking order, as you said, for who gets what. Can you walk us through that typical distribution hierarchy? How does the state decide who's next in line for what could be a lifetime of assets?
Absolutely. And while the specific percentages and thresholds can vary slightly state by state, the typical distribution hierarchy is generally quite consistent across the U.S. It almost always starts with the surviving spouse.
Okay, spouse first.
If the decedent was married, the spouse will usually inherit a significant portion off of the entire estate if there are no children, or sharing it with any surviving children if there are. If the decedent was unmarried or widowed, the assets are then typically divided exclusively among any surviving children, equally, usually.
And if no spouse or children?
After a spouse and children are considered, other relatives come into play.
Yeah.
Parents are usually next in line if there are no spouse or children.
Then siblings.
Followed by siblings, yes.
Yeah.
And then it can go to more distant relatives like grandparents, aunts, uncles, cousins, moving outward through the family tree based on degrees of kinship.
It sounds like a very defined, very rigid structure.
It is. And here's a rather fascinating, though often incredibly sad, point. If no legal heirs can be found at all.
Meaning no one. No spouse, kids, parents, siblings, not even a distant cousin.
Right. If absolutely no legal heirs can be located after a diligent search, any remaining property escheats to the state.
Escheats.
Escheats. It officially reverts to the government. To put it starkly, if you don't make your wishes known through a will and you have no discoverable legal heirs, your entire life's accumulation could end up funding state coffers. It really underscores just how vital this planning is, even for those who think they have no close family or maybe modest assets.
That's a truly sobering thought. Your property could end up with the state if no one can be found. And I can imagine this could get particularly complicated if the family structure isn't what some might consider traditional. You mentioned the strict hierarchy. What kind of real-world headaches do blended families face in an intestate situation?
Oh, absolutely. This is where intestate succession often becomes especially complex and, frankly, can lead to really unexpected and sometimes painful outcomes for families. Let's use an example. Imagine John. He had two biological children from a previous marriage. Then he married Sarah, who brought two stepchildren into the family from her previous relationship.
Okay, a blended family.
Right. And John raised those stepchildren as his own, loved them dearly, maybe always referred to them as his kids. He considered them his children in every way that mattered to him.
Sure, makes sense.
But if John dies intestate, without a will, his beloved stepchildren, who he considered his own, would likely inherit nothing under state law.
Nothing, even if he raised them.
Likely nothing, because intestacy laws rigidly follow biological or adoptive ties, legal ties. His biological children, on the other hand, would inherit, possibly sharing with his spouse, Sarah, depending on the state rules.
But the stepkids get left out?
Legally, yes. This strict adherence to legal ties, rather than emotional ones or lived experience, is precisely why the decedent's personal wishes are so crucial, and why they are so profoundly missed when there isn't a will. It can cause immense hurt and sometimes tear families apart during an already incredibly difficult time.
That's a powerful and, yeah, heartbreaking illustration. It really highlights the gap between personal intentions and these strict legal realities. So let's really try to connect the dots here for our listener. What's the single most significant takeaway from understanding these two paths, testate versus intestate? Why does this distinction matter so profoundly to individuals and their families?
What's fascinating here, I think, is that the key difference really boils down to a single powerful concept: control.
Control.
Yes. With a valid will, the decedent retains control over their legacy. Their chosen beneficiaries get what is specifically designated for them. It's their voice, essentially, speaking from beyond the grave, directing their life's final chapter according to their wishes. Without a will, that control is completely lost. The court looks directly and only to state law to fill in all the blanks. And that often leads to outcomes the decedent might never have intended or perhaps even actively tried to avoid during their lifetime.
Can you give another example of how that plays out, maybe beyond just immediate family?
Sure, we can see this impact clearly with a specific example. Imagine a single individual, maybe an avid art collector, very passionate about it. And they had always intended, maybe told everyone, they wanted to leave their prized collection to a local museum they passionately supported for years.
Okay.
If that person dies intestate without a will, those wishes are legally irrelevant.
Irrelevant.
Legally, yes. State law would dictate that their art collection, like all their other assets, goes to their closest living relatives, maybe a distant cousin who has absolutely no interest in art or that museum.
Oh, wow.
But if that same person had taken the time to create a valid will, leaving everything, or even just specifically the art collection, to that beloved museum, then subject perhaps to certain legal protections for surviving spouses, like an elective share, which is a separate complex issue where a spouse can claim a share regardless of the will, but generally speaking, the museum would receive the assets as intended. This dramatically illustrates the decisive power of a will to actually alter the course of an estate, making sure it reflects personal values and passions, not just bloodlines.
Wow, that specific example truly brings it home. It's not just theory. It really is the difference between a lifetime's passion being honored or just being swept away by impersonal state statutes. It really highlights how much impact a single document can have.
It truly does. And there's another practical aspect, too. If we connect this to the bigger picture, it's also worth noting that intestate estates often take significantly more time to resolve in probate.
More time. Why is that?
And usually incur higher legal fees, too. Why? Because the court, guided by the administrator, has to meticulously follow those detailed statutes to identify all the legal heirs. They need to determine their exact relationship, calculate their shares according to the law, and then distribute the assets. This often involves potentially extensive genealogical research, publishing public notices, maybe court hearings, just to formally confirm who the next of kin actually are.
Sounds like a lot of procedural hurdles.
It can be. This process can be significantly more involved and protracted compared to simply executing the clear, unambiguous instructions of a will, which is hopefully already designated beneficiaries and often provides specific powers to an executor to act more efficiently.
Okay, so to bring it all back to that initial fork in the road we talked about,
Yeah.
the core distinction is undeniably clear. Testate, you decide your legacy. You ensure your wishes, your relationships, your values are honored. Intestate, the state decides for you, following a strict legal framework that might completely ignore your personal intentions or the unique dynamics of your family and relationships. The impact of having or not having a valid will is absolutely undeniable and far-reaching. It affects not just property distribution, but also, importantly, peace of mind for those left behind.
Exactly. And this really raises an important question, I think, for all of us listening. Given what we've discussed today about who truly controls your legacy and the very different paths an estate can take, depending on that one document, what steps might you consider taking to ensure your own wishes are clearly heard, properly honored, and perhaps most importantly, that your loved ones are spared the potential complexities and emotional distress of navigating an intestate process during a time of grief? It's definitely a thought worth pondering and maybe worth acting upon.